I saw her try to join by another method, but I think she's just having some internet problems. I'll reach out to her individually.
Okay.
Evan, we are good to go.
All right, we're live streaming, and this is the meeting of the Cybersecurity and PMBR Committee. And it is the duty of the committee members to avoid conflicts of interest and appearances of conflicts of interest in performing the duties as a member of PMBR Cybersecurity Committee and the North Carolina State Bar. Any member of the committee who is aware of any personal conflicts or appearances thereof with respect to the matters before this committee should disclose those at this time at this meeting. Are there any conflicts? Hearing none, I think our first order of business is the approval of the 7 January 2021 committee meeting minutes. Did everybody get a copy of those and have a chance to review it? And
I move approval there, Evan.
okay.
Second.
All right. All in favor, say aye.
Aye.
The minutes are approved. The next item on the agenda, I think, is going to take us a little bit of time to go through, and it's to review and discuss the draft self-assessment question. And I want to start by saying that the 3 work groups that have rolled up their sleeves and really done some, put a lot of time and energy into this, and I just want to express my sincere gratitude, and Walter too. Walter and I had a discussion earlier this morning, and Walter came up with some really brilliant ideas about how to move forward, and we'll get to those later on. But thanks to each and every one of you. So a lot of work went into this, and there's still a lot of work left to go. Our goal was to try to find and have a finished product by October. And I still think that's within reach. And I think, you know, Catherine and Patty and Warren, I think your work group is still going to be on the bench while we do a little bit more work on this, this self-assessment question. So I'm going to throw the floor open generally first and see if anybody wants to comment about generally or specifically about any one of the 3 working groups' work product.
Well, since you threw it open, Evan, I will reach out and grab it. I want to echo what you said about all the work and the deep thought that went into all of this. And we've got, I guess the problem we have is we've got so much good material, and figuring out how to get our arms around it and put it in the most usable form. And that's going to be a challenge for us, but we've got great thought. People did what we asked to do in terms of not worrying about whether there's overlap. There is overlap, but that's okay because we make sure we're getting all the essentials. And so I think we got a terrific start. I think it was the last meeting where we were talking about format, and as one sort of looking a little bit from the outside, since I wasn't assigned to any subcommittee, in looking at the format of the presentation, Patrick's working group came up with this spreadsheet look that was modeled after one of the other states' assessment tools. To me, that was very readable and very helpful to me in use. Not only you got the question there, you got the ethical implications, and you got resources, and I think that's an awesome presentation. And I'll just comment, I really like that formatting. I know that the publicity group will want to figure out how to fine tune that and best package it for the ultimate assessment tool. But to me, that's a really helpful way to present things. And it's such a wealth of information. It's almost overwhelming. I'll tell you, every time I start reading this stuff, I get panicked about, are we doing all these things? Are we doing everything we can do in our firm? And anyway, so I guess my main takeaway is I really like the formatting of Patrick's work group, and I'd love to see how we can fine tune that and get all of the different assessment approaches into that kind of format. And wondering what other people think about that in terms of a general way to present the assessment tool.
Can I ask a question?
Yes, sir.
Oh, I'm sorry. I'm on this call. I was wondering, I think one of the places where has this self-assessment tool also had that accompanied it a rule that Supreme Court or legislature, I don't know, approved that said that if a firm took this self-assessment tool, that the results of it could not be used or could be basically it was a privilege document that it couldn't be used against you in a future claim, because the point of it was or a future complaint. The point of it was for self-improvement, and if it could then be turned around and used against you in a claim that you checked a couple of boxes and didn't take timely action to fix those boxes, therefore you were establishing your own standard of care, and therefore by breaching that self-imposed standard of care, you had made a claim or would be subject to a claim. And I was just wondering if there's been any thought to that aspect. I think it was Colorado that did that, that has that special rule that says that by taking this, this is not some assessment tool that can then be used against you later in a malpractice claim. Obviously, I have a little
like the protection for an M&M conference for doctors.
Yes, exactly. So I throw that out there as only as another enticement for folks to do this. That might be something we need to explore too.
Warren, I think that once we've got a lot of raw material here, and I think once we pare it down and try to get the formatting consistent and straight before we turn it over to your work group, that's something that your work group should add, I believe, and both in terms of any disciplinary actions or malpractice.
Right.
Yeah. So I think that's a good point, but I think that's some of the finishing touches.
Right. I mean, obviously the information behind doing the self-assessment is subject to discovery, whether in a grievance or a civil case. But I'm just saying, here's a piece of paper that you said it to yourself that something needs to be done. So yeah, we can talk about that too later, but it's just a concern I want to keep in the back of my mind. Our mind.
That should be right in Lawyers Mutual's wheelhouse, though. Really, it's just
yeah. I
don't
want to say it's in our self-interest, but
prophylactically here.
So Evan, Warren has raised a very legitimate issue that some people who live in our world of paranoia might be very reluctant to take any kind of self-assessment. And this is not just going to be a cybersecurity issue, but the whole PMBR movement that we're initiating here just happens to be cybersecurity. And that is a very legitimate issue. And I wonder if we ought to run that parallel to working on this self-assessment tool, so that when we do get this self-assessment tool ready to go, we have that whatever we need to do and moving it through the state bar and getting Supreme Court sign off on it, we have that in place before we ask somebody to take this self-assessment tool.
Well, not having a dedicated IT person that larger firms have. My small firm, if I went through this self-assessment right now, it would be, oh my goodness, we're deficient in so many ways, and really don't have the resources to come up to full compliance with this self-assessment. You and I talked about that briefly, Walter, this morning, but it's for sole practitioners and small law firms. It's going to be difficult to come into full compliance.
If I can just raise an issue here, the problem that what I'm hearing right now is that there's a look at the assessment, a look at what is being required, but literally zero analysis being done secondary to that, that investigation about how much it really costs, what it actually means to put this stuff in place. And I can tell you, as someone who's been advising law firms on how to do this since 2014, it costs 1/10 of what you think it does. The thing that it's going to take is it's going to take your willingness to change your workflow and your willingness to take the time to learn it. And to be perfectly honest, with the amount of time that we spend reading Lawyers Weekly to see what the biggest verdicts were, to see what if there's any highlights or big headlines coming out of the Court of Appeals, that time we could literally add 10 minutes a week to learn, to go through making sure that we are just quickly up to date on something, or to learn and something new about one of the piece of software that you already have. We are talking about giving a liability exemption, which could, in my opinion, be used in bad faith by firms who simply take the survey in order to provide almost a basis to avoid any investigation or further discussion about whether or not they've done what they need to do to determine if they're weak. If this is the only thing the state bar is going to have to determine whether or not you have any cybersecurity protections or that your cybersecurity protections are up to snuff, then simply allowing someone to take it and then have that disappear into the files of no, we're going to have this secret discussion among ourselves and no one else is going to be able to use it against us, and then have no other way to investigate whether or not that firm is in compliance with reasonable standards of cybersecurity, I think sets a potentially dangerous precedent. I definitely understand the idea of wanting to give incentive for this to be taken by small firm lawyers, but I think one of the biggest things that we need to do right from the start is we need to educate people about this, how inaccurate this mindset that coming into compliance with basic security protections is going to cost half your law firm's revenue and a year of your time. It's simply not true.
All right, I see Patrick and Catherine have their hands up, and so does. So let's go to Patrick first, and then we'll go to Catherine, and then to Warren.
Oh, Catherine, you raised before me, so I'll defer to you if you'd like to go ahead.
Sure. I was just going to say that I think we have to address this issue of whether or not we're asking law firms to create evidence against or for themselves from the get-go, because it's going to be really hard for me and Patty and Warren to market something when the first question we're going to get from lawyers who are trying to do this is, well, do we have any protection on filling this out? And if we can't answer that question, then that's going to be difficulty number one. Number two, if we say, nope, there's no protection, this could be discoverable. I think you're going to have people who it's just going to fall into the narrative that all the state bar is doing is not truly trying to help us. They're just trying to trap us. So I think as to whether or not there will be some protection in someone's participation in this filling out this self-assessment, I think that's a crucial issue we need to know now.
So what you're saying, Catherine, is this is a predicate issue and not a sort of a finishing touch issue.
Correct, Evan.
Okay. All right, Patrick.
So definitely echo what Brian said. Not going to repeat it, but very valid points. The other big thing with this issue is if a firm isn't following good practices and they have a breach or they have an issue happen, most small businesses go bankrupt after events. The real stick is if you don't do this, you're going to get sued, you're going to go out of business, you're going to be looking at bankruptcy. Quite frankly, I don't see the state bar ethics stick as the biggest risk or even a significant risk for firms in not implementing cybersecurity practices. It's definitely one that we have a duty for. It's something that the state bar is rightly looking at, but that's not the risk that firms should be concerned about, in my opinion.
Warren?
So I don't see a big issue with us, finding a way to scale down the ethics risk.
I mean, I hope I wasn't misinterpreted. I'm by my suggestion, I'm not saying I'm trying to help lawyers hide things from the state bar or from potential claimants and stick their head in the ground. That's absolutely not what I'm saying. I'm saying why, in trying to help yourself, why should you create evidence against yourself if something happens? And if all the underlying facts that go into the answering of this questionnaire are otherwise discoverable, then that's in anything, then that's fine. I don't. There's nothing that we're doing here to try to set back people by having this suggestion that in order to make it more enticing for the law firms to try to do it, that they have some comfort that they're not walking into a briar patch. Man, I don't know. I don't see why that's too controversial, but maybe I'm too self-interested.
All right. Barbara, you got your hand up. You need to unmute yourself. There you are.
I just don't recall that from the beginning, this was called the proactive, it came under the umbrella of the proactive management-based regulation. And I thought from the beginning, the desire was to provide information, to do self-assessments and let lawyers improve. I don't recall us ever talking about collecting information that could be used against somebody. It just seems to me that that is contrary to what we've talked about from the beginning.
Barbara, you would be correct in that all of the PMBR related information that the PMBR committee considered before these two were put together was exactly what you said. The goal of any PMBR related program is to positively move lawyers in the right direction. And Warren did remember correctly that, and I think it was Colorado, I haven't had a chance to cross check. Brian's shaking his head yes, so I think that's right. That because they had two versions, one you could go in online and complete and one that you could print off and complete. And they kept those records separate from anything that could link the lawyer who completed the assessment to the actual assessment itself. And I will say, having seen what has happened with the wire fraud education that the State Bar has had a part in bringing forward, there is value in this information just being out there and available, even if a lawyer opens the webpage and mentally takes the assessment and chooses to make some actions as a result of that. So I think that the committee should keep that in mind also as it wrestles with these issues.
Let's see, Brian, Folk, you're got a hand up, and then we'll go back to Catherine.
Yeah, I think that the bigger question in my mind is whether or not participating in this, if there's going to be something of value, if we are actually going to be contributing something of value to a law firm, then it's going to be information that is effective in helping improving their cybersecurity, which also means that they would thereby be on notice that their cybersecurity was either insufficient or that there were ways that they could fix it. I think that there is my personal concern as someone who litigates these issues is whether or not, if this is going to be the only significant material provided by the state bar, while at the same time the North Carolina State Bar has been among the leaders in the United States in how our state bar approaches the combination of ethics and technology. It's one of the things that when I was blogging about it, I was actually always very proud of how effectively the state of North Carolina handled ethical issues in technology. But if we're going to take our position on ethics, which is basically that lawyers do have a duty to stay on top of trends in technology, which includes cybersecurity. You have a duty to protect your client's confidential information, including when that information is being kept electronically. If we're going to do all of that, and then the only significant information provided by the state bar is somehow, like 100% exempted from any kind of question, all of a sudden you raise this issue of, okay, is a lawyer on notice that their security systems were insufficient? I understand completely this idea that we want people to take this survey. I just have I run into in seeing how this is playing out in real time. I've seen lawyers deny that they had any idea. These are real estate lawyers now deny that they had any idea that there was a reason why they should call and confirm a wire transfer instruction. And I'm talking about a case that dealt with a transfer within the past year. If the biggest issue in cybersecurity is going to be whether you are on notice that your systems and your policies were insufficient, and this is the only thing the state bar is going to have out there, I think that creates a really, really, I don't even say perverse incentive, but a strange incentive to me, because one of the only ways that I have to demonstrate that a lawyer was on notice is the emails and the information that they got from the state bar. So if we're saying that our profession is exempt from this idea that information provided by our credentialing body is somehow not actually going to provide any legally recognized form of notice to our members, I think that's a problem. I don't know how we get around it, to be perfectly honest. I'm not saying I have a solution. I'm not saying I would oppose a solution that incorporated some kind of a protection waiver. I'm raising the issue because I see it and I think it's a big problem.
All right. Catherine, you had your hand up. No? No, I want to go back to what Leonore said, just to kind of put this into some historical perspective. And I think, Patty, you've been in since the beginning, and this thing started with a survey of all kinds of different areas of practice, and Catherine, you've been on this too since the beginning, I think. And the idea was to create some tools to assist lawyers in managing their practice and keeping them up to date. And that was the purpose and the reason behind PMBR. Last year, we shifted to this single topic. And I have to agree with Brian that the bar should be in a position to assist lawyers in understanding the landscape of cybersecurity and technology, and have some self-assessment tool or some self-help tools and some resources to assist. And that is the prime directive of this committee. And Catherine, I understand your position of how are you going to sell this when lawyers are going to feel like they're exposing themselves. But Leonore also makes a good point that that lawyers can go to the resource that we create, assuming we create a good resource, and do a mental assessment or a mental checklist, and or just learn what needs to be done without creating some kind of document or discoverable instrument later on. It will, however, set a standard of care, I think, for lawyers if we do put a self-assessment tool out there. And Brian, would you agree with that this is going to create some kind of standard of care if once we get a polished version and have it on a website?
Well, I think that, provided that any self-assessment tool includes what I would think is a necessary disclaimer at the top, that cybersecurity is completely idiosyncratic. It is something there is no one size fits all. I think that actually helps mitigate the question of whether it's creating a standard of care, because it basically says that the standard of care is going to be very, very specific to your type of law firm. The bigger question in my mind is whether and from a purely technology and ethical perspective, if I'm looking at what I think all law firms should have to do in an ideal world, these are things for the most part that are relatively easy steps that will, as I keep trying to tell people, you're not trying to make yourself impregnable, you're trying to make yourself a harder target. You don't need to outrun the bear, you need to outrun the person next to you. So if all you're trying to do is get yourself up to the point where you have basic security in place, you've taken it seriously, you've looked at your system, say, what can I do to be a little bit better? Then that's one thing. But it does mean that every lawyer who participates it will be on notice that they have that their basic security should include this. I don't know if it creates a standard of care so much as it creates a notice issue. And in the cases that I've dealt with, notice it is not the standard of care. It is actually more at the very front of any lawsuit against you. It's going to be, did you know that you should have done this? Okay, if you did, then the lawsuit proceeds. If you didn't, then we have to take a real look at whether or not this is something that's even something that you could be sued over. Whereas standard of care, I'm coming from medical malpractice training, I come down to, okay, once the experts have been deposed, once all the facts have come out, that's when you really make a standard of care assumption. And I don't think that this tool would actually be all that effective, because it doesn't provide that ground level granular detail that would really be necessary to come to a standard of care opinion. But it does get past that first hurdle. Were you on notice?
All right, Colin, you got a hand up.
Thank you. I was just wondering, and maybe Warren or somebody who deals with insurance matters knows, it would seem to me that folks like Lawyers Mutual or other insurers, as part of their underwriting process, go in and ask people these kinds of questions on whether it's cybersecurity or fire or whatever. How do you get that information for an underwriting purpose without creating the same weapon that might be used against someone?
I can say, as someone has helped write some of these policies and does a whole lot of work with companies who are applying for cybersecurity, the forms that most of them fill out, ours looks like an Encyclopedia Britannica of cybersecurity compared to some of these forms. I mean, it is such minimal information that is required, unless you're getting a really expensive policy or getting really specific changes, like you want to make sure that your certain payments and everything are laid out a certain way, or if you're actually asking the insurance company to come and provide training, things like that. You don't get that much of an investigation from most insurance companies. And part of the reason is because these policies have significant exclusions.
Okay, Barbara, you got your hand up.
Yes, I was just going to address part of it and say, to Brian that just the very fact that the information is available, you used the wire frauds as an example. So I'm thinking not from the malpractice side, but from the grievance side. And the grievance committees have looked at to say, at the very beginning, we weren't going to hold lawyers responsible for knowing about this. But now that the state bars put out the information, the title insurance companies, and it's widely available, they are holding lawyers responsible for that knowledge. And I think that's part of the point here. I think it's correct. The fact that we have this tool, I don't know, I want to say it sets up a standard of care, but it is information that's out there. But we're not the only ones that are providing it. I mean, there's CLEs they have to take on technology. And I think our point is just we're all better served by getting the information out there as much as we can. And we're assuming that lawyers want to improve. That's what's motivating them.
Colin, you still have your hand up. You want to say something? Okay. Any further discussion on this issue? I'm not sure we've come to any kind of consensus, but I'll try to summarize if there's no further discussion. Anybody? Do I see any hands up? Judge Cobb, yes, sir.
Did I hear early on that Colorado had some type of waiver in their model? And if so, would it be beneficial to assign somebody to check on that history as to why and how they came up with theirs?
I will double check that. That's my recollection, not a waiver, but you do have the option. I think they have a confidentiality around theirs, and I'll double check and get back to the committee with a more detailed and specific answer about that.
Well, quickly on that, they do. They have a rule of civil procedure. Actually, they adopted a new rule of civil procedure, Rule 256, that concerns their self-assessment program and deems the self-assessment program confidential, that the confidential information shall not be utilized in any disciplinary or disability complaint. It really goes to the grievance aspect of their regulatory process. But I do recall the person that presented from Colorado when we met in person back in, I guess that was July of 2019, I think. And the person that was running the program in Colorado mentioned that. And I think that, if I recall, Leonore, I think you and I were both kind of like, oh my goodness, they actually adopted a new rule of civil procedure that, they had to go through a couple steps to get that, but that was the protection they put in place. You can imagine that'd be a pretty significant undertaking here in North Carolina to do something similar, but it's certainly something to look at. I've got a copy here. We can send that out to the committee for their consideration.
Okay, Judge Hennett, you have your hand up.
Yes, I'm sort of dovetailing on what Judge Cobb has suggested, and that is that we find a way to put something in the document itself to say to lawyers that participate, other than just mentally going through it on a notice basis, that it is something that we will not retaliate against them for their participation or any negative information that may be given in the survey. And I think what Leonore, or Ms. Hodge rather, has said that Colorado presented something to that effect would then bring in what Ms. Christie has suggested, that when we set out to do this, it was more of a helpful tool, and that we would give assurances to the participants that it was for them to use to sort of guide themselves in how they both set up their practice and ran their practice, and not as something that we would use in an affirmative way to attack them or to prosecute them. So I would suggest that we include some language to give that reassurance so that people will not shy away from engaging in it.
Barbara, you still have your hand up.
I do. I guess just back to the beginning, I wasn't sure how this was going to be set up. Are we going to attempt to, if they go in and take it online, would we have a record? So somebody could pull that individual assessment and look at it? Or are we going to try to aggregate information? I mean, if people are allowed to print it off and just do it manually, we wouldn't get that anyway. I mean, so it may be kind of a moot point.
Yeah, that's all to be determined after we get a finished product, really.
All right.
So should we task Catherine, Warren, and Patty with trying to craft some and wordsmith some language that might be added to this product and have it ready at our next meeting? How do you guys feel about that, Catherine, Warren, and Patty?
I'd be willing to do it.
All right. I'm still a little, I think that I'm of the opinion that this is a self-help tool first and foremost, and that this is kind of it's more of a reassurance than it is anything else. But I think the purpose of this committee is to try to get a helpful tool out to practitioners so that they understand what's going on in the world of cybersecurity. So we only have about 20 minutes left. So I want to talk about a couple of things. This is Walter Brock's suggestion from this morning when we talked. What we would suggest at this point is that we would have Patrick's subcommittee or work group work product reviewed by Brian's work group, and Brian's work group's work product reviewed by Patrick's group, because you guys are the subject matter experts in this, and I want to hear from both of you, from Brian and Patrick, about how you feel about that. Patrick?
I think that would be a good idea, having the different work groups review the materials, be a little bit more efficient than trying to review everything in a committee meeting. And it's, it's Alan and Ted and Takia and Patrick's working group.
Right.
It's not just Patrick.
That's shorthand. I know that, and I know how hard everybody's worked on this. Yeah. So yeah, I know that, and I know.
I want to make sure everyone's getting credit.
Yeah, and same with you, Brian and Jerry, and everybody that's on your work group. But you okay with that? Everybody on what shorthanded is called Brian's work group.
Yeah, I mean, it's certainly fine with me. I'm happy to take another look at it.
Great. I think we had discussed that in an earlier meeting, that we were going to kind of rotate the work products around to the different work groups. Walter and I have felt a little bit guilty about not being in the trenches with all you folks that have worked so hard. So Walter and I have volunteered to review the staff awareness office culture group and start kind of going through the details and wordsmithing on that. Anybody, unless somebody else wants to pick up the laboring oar on this and pick that up. Any discussion on that? I see Judge Hennett's hand up.
No, I was holding my chin, but actually, since you called on me, I will say something, and I will say I'm delighted to see you take part in doing that.
Great. Yeah, but I'm gonna lean on Walter a lot. He's the man with a lot of ideas and solutions. I call him the solution man, really, because he comes up with solutions to most problems.
Jobs for others to do is another way to put that, Evan.
Yeah.
And I think we talked also about maybe targeting a meeting between council meetings, maybe in about a month, to discuss the process, discuss our reviews, and maybe also tasking these reviewers with paring down because we have so much, so much good stuff, but it's pretty much overwhelming if we could, with an eye towards paring down to some of the essentials. And it's a little easier to do if you're looking at somebody else's work,
Right.
to make suggestions on how to pare it down.
And I think the format of shorthand name Patrick's work group is a good one, unless somebody else has some better ideas on how to format it. So I think we all want to have consistency in formatting. But I think we probably ought to set a date a month out to have this work completed. How does that sound to everybody? Do you think we can get this done in a month or so? Hearing no. Leonore, let's set a date and for people to have completed their reviews and editing and suggestions. And then we'll set up another Zoom call about a week after that for another meeting. And I hope at that point we have something to turn over to Catherine, Warren, and Patty. They're chomping at the bit to get on the court.
See, Brian has his hand up.
Yes. Hi, Brian. Yeah.
One quick response to what Walter just said. One of the best ways that I've found to be able to provide information for this is to essentially rely on nested questions. I think that one of the biggest things, if we can narrow down the big topics and then have the responses that if someone enters actually trigger further questions, that allows us to avoid having to ask a list of 20 questions that all seem to kind of roughly deal with the same thing. It improves the simplicity of design of the whole question format. People don't have to answer or go through questions that are not relevant to them. And I think it is something that the cybersecurity audit in itself actually really lends itself to. So I think that is one thing that we could look at when we're going through these questions, finding out whether or not there may be another way to phrase some of them instead of as individual questions, but rather as nested questions based on a response to a previous question. It can be can cause a little bit of complication for whoever's editing it, just because they have to be able to understand that. But given that we're the ones crafting it, not the ones taking it, I think that we can probably deal with a little bit more complexity in order to make it a lot simpler for everyone else who's using it. That's just a suggestion based on my experience. So,
for example, Brian, the third-party vendor checklist seems to be the nested question.
Yeah, that's it. It was designed like that. Now, I also put that together 6 years ago. So there's questions in there that may be a little out of date, and maybe a better way to do that, because I probably did that at 11 o'clock at night as part of a blog post. So.
But yeah, I think we discussed that at the last meeting, the nested question format. So, if yes, this, if no, this. So yeah, I like that. Maybe we can focus on that some. Anybody else have a hand up or want to discuss anything? Leonore, do we need to set a date, or do we want to send it out by email? How do you want to do this?
Since the committee has said 1 month from today, that would be Friday, May 14th. And then what can be circulated is a doodle poll for availability to schedule a meeting that week of May 17th, if that would work for everyone.
Okay, does that work for everybody? I don't think we need to do anything by motion on that. I think we can just schedule it, can't we? Mm-hmm. Okay. I think that covers the agenda. Any other matters that come to mind? Anybody wants to put on the floor? Walter, you got anything to say? You're unmuted.
Oh, nothing to add. Right. I've been good.
All right.
Way to move along here.
Okay, Alice, you want to throw anything in on this?
You want me to throw something at you? Is that
Yes,
what you're asking
please.
for, Evan?
I
No, I don't. It's always interesting to listen and hear lawyers debating important issues that relate to our professional responsibilities and the impact on clients and all of that. So I enjoyed the discussion about the liability question. So kudos to your work, your continuing work. I think this is important, and I think it's going to be a great product once we have it done. So thank you all.
Well, like I say, I thrive on humiliation and rejection. So throw anything you can at me. All right. Well, nothing. Ted, do you want to throw anything in on this? Ted Edwards?
No, I'm
all right.
happy.
Mark Enriquez, you're always ready to throw some verbosity at the committee.
I am always happy to, but I think this is good progress, and I'm pleased with where things go.
It is good progress. I'm really just proud and happy that the work groups have done such amazing work. So once again, thanks to everybody. So with nothing else, we'll adjourn, and we'll see everybody later in the week, I guess.